Yes, we have, Your Honor. May I approach you first?
Yes.
You've left blank, and I'll give a copy to the defense advocate, the boxes that have them to you.
Thank you. Ms. Stansel, have you had a chance to talk to Mr. Erickson, and do you waive any formal reading and advisement?
Yes, Your Honor, we have had an opportunity to speak with him, and we would waive any and all further reading and advisement.
Thank you. Have you had an opportunity to take a look at the protection order?
I have not.
Time to approach.
And Your Honor, would you like this copy signed, or would you like me to return this copy?
That copy can be signed, but I haven't filled it out yet, so if you're comfortable signing it, that's fine. If you want to wait until it's filled out, that's fine too. Thank you. Any record from the people of the 18,000?
Your Honor, I presume the court would do this, but I'm going to say it the same way. No contact with any protected parties that are identified. No alcohol or drugs, obviously. No firearms or other weapons. And do not return to STEM High School.
Any objection to those requests?
No objection.
So, Mr. Erickson, I am entering this protection order. It's mandatory pursuant to 18-1001. It says that you shall not harass, molest, intimidate, retaliate against, or tamper with any of the witnesses to or victims of the act you are alleged to have committed. The victims were named in the mandatory protection order, the specific people that you shall not have any contact with. You'll stay away from the homes, their homes. You'll stay away from any other location that they are likely to be found. You'll not contact directly or indirectly any of those folks that were named in the protection order. And you shall not communicate with them. You shall not possess or purchase or control a firearm or any other weapon. You shall not possess or purchase any ammunition. You shall relinquish, appreciating that you are currently in custody, any weapons that are in your possession. We'll talk about that in just a minute. You shall not possess or consume any alcoholic beverages or other controlled substances. And you may not return to the STEM school located at 8773 South Ridgeline Boulevard. You also may have no contact with the co-participant. Are there any questions about this protection order? Violating this protection order, Mr. Erickson, would result in additional criminal charges. Do you have any questions about that? I need an out loud answer.
No.
Thank you. motion filed by the people today regarding suppression of the case. Mr. Buckler, you asked me to address that today.
Yes, Your Honor.
Any other issues that we need to address today before we get to that?
I presume the court will want to discuss bond, at least till the filing of charges and then the scheduling of that, but whatever order the court wants to take this up.
Yes. Other than that, anything else?
May I have a minute to talk to someone smarter and greater? Nothing else, Your Honor. Thank you.
Your Honor, we agree with the suppression, and if anything should change as far as the people's position regarding suppression, we would ask that we be allowed to be heard before the court rules on such a change.
Okay, so the motion to suppress was the entire file. And defense agrees.
We agree.
Your Honor, this is a temporary order that we seek for suppression, and I want to be clear on the record for you and the public that that is just during the early stages of this ongoing investigation. I do not intend to ask this court to suppress this file in perpetuity or even through the duration of this case, only until such time as the investigation gets to the place it needs to be before this information can be more publicly accessible. I'll tell the court that we are going to come back to this court and ask the court to unsuppress the file, but there will be documents that we'll ask the court to suppress individually. Those documents will relate to that protection order that the court just gave that has identifying information about the specific victims in this case. But at this point, those are the only things we've asked the court down the road to consider. I just want to put in context our request for suppression in the very temporary and short term.
Anything else for the defense?
Just that we're requesting notice and the right to be heard before any change is made.
With respect to that, if the court's inclined to grant this in the short term, could we tentatively schedule to revisit this issue at the time of the filing of charges and then have a discussion about whether or not it should be extended beyond that day? And that way, that'll put you on notice as well to come prepared.
So I'll grant the motion for today for the reasons that are stated. It won't be tentative. We'll readdress it at filing of charges.
Thank you.
Bond. Does the defense wish to address bond today?
Your Honor, we asked a request to address bond and filing of charges.
So when Mr. Erickson remains on the no bond hold until filing of charges. Anything else on that issue from anybody else?
Not from the people here.
None from the defense, Your Honor.
Yeah, something on that record, Your Honor. After I said no, I realized I left out one important thing. The parents of the deceased in this case, Mr. and Mrs. Castillo, are present. They've been consulted previously about this proceeding, as well as the likelihood that bond would remain no bond to this part of the provision, for this part of the hearing and the process, and they're in agreement with that. We've also heard from another victim's family. Just to put that on the record, Your Honor, we've consulted with as many victims' families as we could in this short period of time. All of the ones from whom we've heard have all said they're in agreement with the no bond.
Filing of charges Friday at 8:30.
Your Honor, respectfully, I think we have up to 72 hours with the court permission. Here's what I'd respectfully request. Because of the issues that we've put on the record with the investigation, if the court would, and I believe it's entitled to, schedule filing of charges for Monday. That would give this investigation an extra 2 days, Saturday and Sunday. We have not calculated the 72 hours. To continue to make progress such that when we return on Monday for that filing of charges, these issues of suppression and any other expanded media coverage and other things will be in a, my hope is a different posture because the investigation will be that much closer to being wrapped up.
Your Honor, we don't have an objection to having the filing of charges on Monday. I do have a conflict in the afternoon, so if it's possible to set it at 10 a.m., that would be better for us, but if that's not possible, we'll make it work.
This court cannot accommodate a Monday setting this particular case.
What time did you say on Friday that the court proposed?
8:30.
Is that AM Mountain Time?
Yes.
Would the court consider Friday, but later Friday? I don't know what the court schedule is in the afternoon. Again, I'm really just bargaining for as much time as possible for us to complete the investigation and make smart filing decisions up front.
So we be available at 1:30?
Yes, Your Honor.
Have a moment, please.
You may.
Your Honor, with court permission, can I speak with the defense counsel?
Okay.
Thanks, Your Honor. Thank you for that time. And did you say Friday at 4:30, Your Honor?
1:30. Anything else?
Not from the people on that issue, Your Honor.
Nothing further on that issue, but I do have other issues to address.
Go ahead.
Your Honor, at this time, I would revoke on behalf of Mr. Erickson any prior medical or mental health waivers that he may have signed in his time at the jail. I would invoke his Fifth Amendment rights, his Sixth Amendment rights. I would also, and I'll note for the court that I'll follow up with written motions as to these issues, but I'd just like to put on the record that we are asking the court order that all evidence be preserved, including written notes, and that the scene be preserved and not be released without notice to counsel and an opportunity to be heard about whether or not we could have our own investigator go to the scene.
Anything else?
Nothing further at this time.
Well, all but the request for evidence to be preserved, including the scene, are simply notices, and certain people heard those. Mr. Bumper, regarding the preservation of evidence, starting first with just the preservation of evidence, not the scene. Let's start with just that.
Now, Your Honor, we're going to comply with Rule 16. I'll affirmatively say we're going to comply with Brady v. Maryland and all of the other cases that have flowed from it. If there's any consumptive testing, we will certainly let the defense know in advance of that to the extent that they're still on the case. You want us to address the scene separately, Your Honor?
Yes.
Okay. Thank you.
Anything else on that, Ms. Stansel? Not the scene, just the preservation of
Nothing
evidence.
else on that.
I'm certain that people will comply with Rule 16, specifically if there's anything that, any consumptive testing, I am requiring the district attorney to not perform that testing until the defense is notified, and if they want an opportunity to be heard, that there's enough time to file. So until there's a court order. Preserving the scene. Request to preserve the scene. Mr. Barker.
May I have just 1 second, Your Honor?
You may.
Your Honor, I suppose it's going to have to begin with the definition of what preserve the scene means. Because right now, as we speak, law enforcement, both federal and local, are engaged in the processing of that scene, the process of processing that scene. Things get moved, things get cataloged, items get tested, documented, all those other things. I don't think it's appropriate. I don't think there's any precedent for us allowing the defense, either as attorneys or their own hand-picked investigators, to shadow investigations as they continue to process that scene. So to the extent that that's what they mean by preserve the scene, I object. If instead what they mean is, look, at some point after the scene has been processed, we would like the ability to conduct some type of a walkthrough of that scene with law enforcement there just to, for whatever reason, they hold on to the scene. I can have that conversation with law enforcement, Your Honor. We don't own that building. That is a public school building. I don't have the ability to dictate what happens or doesn't happen.
Your Honor, to be clear, we are asking for both. We're asking for access for our own investigators to be present while the investigation is being conducted and to shadow investigators. And then secondly, should the court deny that, we are asking to have access to the scene before it is released to the community so that we can have our own investigators walk through and make observations, take photographs, etc. before it's released.
Anything else? From anybody else?
Your Honor, if the court's inclined to do this, I would try to find out from law enforcement when they think they're close to finishing up the forensic analysis of the scene and the processing of it. And before it is cut loose back to who owns the building, provide notice to the defense of that. And if there's a conversation that needs to be had with the court on giving them a walkthrough, we could do that then. Just trying to be as amenable as possible to accomplishing what they want.
Can counsel approach? Anything else on this issue?
Not from the people.
None for the defense, Your Honor.
The request to have access for investigators to essentially be at the scene while law enforcement is processing, photographing, doing their own investigation, that request is denied. But I will reserve the issue of access to the scene after investigators have finished their investigation and before it's released back to the community. So if that is to occur before Friday, people are to give defense notice with enough time for defense to request a hearing. And it won't be released until further order of court. If it's not going to happen before Friday, we can address it again on Friday. Make sense?
Understood, Your Honor.
Thank you, Your Honor.
And Your Honor, forgive me, and we probably didn't clarify this on the record. By the scene, I presume we're talking about the STEM school.
That's correct.
Okay.
Anything else we need to address today?
Your Honor, I didn't hear that the court ordered that all prior written waivers are revoked. For the court.
I did. People acknowledge that they heard that. That's really within your discretion, the defendant's discretion. I'm not ordering that. You revoked those. People acknowledge they heard that.
We do.
Thank you.
Nothing else from the people, Your Honor. Thank you.
Nothing else from the defense, Your Honor. Thank you.
We'll see everybody Friday at 1:30.